Let's talk about Gundy versus the United States. So this, if you have an admin law textbook, you probably know, is a really long case, but fortunately I am here to break it all down for you. Going to give you a summarized version of the facts, the holding, the concurrence, and the dissent. So Gundy basically revolved around SORNA, the S Offender Registration and Notification Act. And basically SORNA gave the AG, the Attorney General, the authority to decide whether a 2006 DOH requirement that S offenders who are convicted register in every jurisdiction that they work, that they're a student, and that they reside. And so Herman Gundy was convicted before the S Offender Registration Notification Act. So he's the challenger here. So the AG has this power. They get to decide, does it apply to those convicted before or not? And the AG ends up saying, yes, it does apply to those convicted before. So Herman Gundy's mad about this. He challenges this as an unconstitutional delegation of power. And this makes its way to the Supreme Court in 2019. Justice Kagan, an administrative law expert and an amazing writer, writes the majority opinion. And it's not even close in her opinion. She holds that, no, this did not violate the non-delegation doctrine. This is clearly based on an intelligible principle, this delegation, meaning that Congress basically gave it enough standards, enough of a confinement to not be an overbroad or extreme dose of discretion. The AG has this discretion. Yes, it's a good amount, but it doesn't violate the intelligible principle doctrine. And she even says that if this were unconstitutional, much of the federal government would be downright unconstitutional. So yeah, it is not even close in Kagan's eyes. Then we get to the concurrence written by Justice Samuel Alito, very conservative guy. He says, I would prefer it if we were to reconsider the approach of the non-delegation doctrine that we've adopted through the past 80 years. He thinks it's questionable, but since the majority is not willing to do this, I'm just going to go along with this. Basically, he thinks that a lot of other delegations are similar to it, so why single this one out, really? So yeah, it would just be wrong to give it special treatment in Alito's view. And then we get the dissents from some conservative justices. We get Gorsuch writing, and he's joined by Roberts and Thomas. Gorsuch says that this gives the Attorney General the power to write his own criminal code for this group of people, the convicted S offenders, and just because they're a group that we don't feel much sympathy to, in fact we look down upon, doesn't mean that this doesn't have big implications for what the AG and what Congress might have power to allow administrative agencies to do next. So yeah, this is unconstitutional in their view, and they basically argue for abandoning the intelligible principle doctrine. They don't outright say that, but they favor an approach that's much more of a fill up the details approach. Congress does most of the work in the delegation, and then the administrative agency just does the work of filling out the details. So they say that a statute provides an intelligible principle if three circumstances are met, and only if these circumstances are met. So first, the statute needs to assign to the executive branch only the responsibility of making fact-finding. Second, the statute needs to set forth the facts that the executive must consider and some criterion that they need to measure it against. And third, and most importantly, Congress, not the executive branch, needs to make the policy judgments. So this dissent is obviously not binding law, but why it's important is because it kind of indicates where the Supreme Court might be headed. As I said, this was a 2019 case. This was before Justice Ginsburg was replaced by Justice Barrett. And yeah, the Supreme Court already overturned Chevron deference, so we see that a lot of these conservative types are very anti-administrative agency in general. So we shall see if they revisit the idea of non-delegation doctrine, if they throw out intelligible principle and make it much harder for Congress to delegate its lawmaking power to administrative agencies. It's really going to be interesting and wild. But yeah, if you like this video, if you found it helpful or interesting, please leave a like, comment, and subscribe. I really do appreciate it, and I will speak to you in the next video. Thank you.